Hi, good evening. This is a Supreme Court judgment under the Income Tax Act. Citation is Pride Forumer S.A versus Union of India. Issues before the Supreme Court. There were two issues. One is when a lull in business, lull or dull, you can say, is said to be cessation of business. How to find it out? Two, this is an incidental question whether a non-resident company making business communication with an Indian entity from its foreign office, can it be said to be carrying on business in India? These are the two issues before the Supreme Court. Facts of the case, I will call this uh, France company, Pride Forumer, as PF. So PF is a non-resident company incorporated in France. It was engaged in business of oil drilling. Initially, it was awarded a 10-year drilling contract by ONGC from 1983 to 1993. Thereafter, PF failed to procure any contract till 1998 from the ONGC. But they were having continuous correspondence with ONGC from their foreign office with regard to hiring of manpower services, etc. PF also attempted to secure a bid in 1996, but that was unsuccessful. PF was incurring various expenditures like administrative charges, audit fees, etc. So they filed their income tax returns for the assessment year 96, 97, 97, 98 and 99, 2000 showing nil income. Our income is nil. The only income credited was under the head income from business on account of interest. Against this, PF claimed business expenditure, the administrative charges and audit fees, legal fees, etc., and deduction on account of unabsorbed depreciation on furniture and fixtures brought forward from the earlier years. AO disallowed the claim on the ground that PF was not carrying on any business during the relevant assessment years because they were doing business only up to 93. After that, till 98, they were not doing any business. So he disallowed the claim. Then they filed appeal before the CIT. CIT appeal also confirmed the order of AO. Again, PF filed appeal against the order of the CIT appeal before the ITAT. ITAT allowed the appeal of PF on the ground. A temporary discontinuance of business may give rise to an inference that the business is going through a lean period of transition and it could be revived if proper circumstances arise. ITAT allowed the claim and held a temporary discontinuance of business which can be termed as lull in business. So this is only a lull in business as far as the assessee is concerned, PF is concerned. Intention of assessee, that is PF, was never to go out of business, and hence it cannot be concluded that PF had discontinued its business. That is the reasoning given by ITAT, and then they allowed the claim. Then department filed an appeal against the ITAT order before the High Court. High Court agreed with the view of tribunal that lull in business does not mean discontinuance of business. But finally, they allowed the department to appeal on the ground that PF had neither permanent office or any other office in India, nor any contract was in execution during the relevant period. Hence, they cannot be said to be carrying on business in India, and hence they disallowed the claim of the PF on the administrative charges, legal charges, and carry forward depreciations on furniture and fixtures. So now, against this order of the High Court, appeal was filed before the Supreme Court. So, again, to uh, 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 the issues, the two issues before the Supreme Court was Main issue was this one only. When a lull in business is said to be cessation of business, how to find out? That is the point. Secondly, whether a non-resident company, that is an incidental question because of the High Court view, whether a non-resident company making business communication with an Indian entity from its foreign office, can it be said to be carrying on business in India or not? That was the incidental question. The relevant sections are, I need not to say if you are an expert in income tax or a chartered accountant, but for the purpose, for the sake of completion, for the sake of giving the full view, section 37.1 read with section 71 and section 32.2 are the sections. Then section 9.1.1 also, that is also relevant. Section 37.1 says, simply put, I am not going to give the entire section, so that will be longer than the judgment of Supreme Court. I am just going to give you the highlights. Section 37.1 says, any expenditure incurred wholly and exclusively for the purpose of business or profession, it shall be allowed to be deducted in computing the income chargeable under the head profits and gains from business and profession. It may be set off as a loss against any income under any other head subject to section 71. That is what section 37.1 says. Section 32.2 says, it provides for unabsorbed depreciation allowance for the previous years. The condition is given under the first proviso. The proviso states that such depreciation can be carried forward if the business or profession for which the depreciation allowance was originally computed continued in the previous year, relevant to the assessment year in question. So in the previous year, you must have continued the business. Otherwise, depreciation allowance cannot be given. This part of the proviso was omitted by Finance Act 2001 with effect from 1/4/2002. That is also an important point that should be kept in mind because the assessment years which we are dealing with are prior to this. Supreme Court said, for claiming the benefit, assessee has to demonstrate that it was carrying on business in India during the relevant period. For claiming the benefit of allowance of expenses and the depreciation claim. Supreme Court said the conduct of the assessee must be seen whether the failure to procure the contract is due to disinterest to carry on business, which will amount to cessation of business, or he was interested in carrying on business but he could not secure the contract. That has to be seen. Conduct has to be seen from the point of view of a prudent businessman, not from the point of view of a lawyer or a judge. I am saying these two words are added by me. Conduct has to be seen from the point of a prudent businessman. If the conduct shows that there was an intention to carry on business, then mere failure to obtain business contract will not be the determining factor. Supreme Court agreed with the tribunal's view that mere lull in business does not mean complete cessation of business. Supreme Court said the word business has a wide import and connotes some real, substantial and systematic or organized course of activity with a set purpose. It relied on its own judgment on Malayalam Plantations Limited, which held that the expression for the purpose of business, within quote, for the purpose of business, is wider in scope and it would encompass many other acts incidental to carrying on of business. So it says, simply put, for the purpose of business means it will include all the incidental acts also to carry on the business. Supreme Court said, on the facts of the present case, PF was corresponding with ONGC with regard to supply of manpower. Even though it was not doing business in India, it was corresponding with ONGC with regard to supply of manpower from its foreign office. Further, it was unsuccessful in its bid in 1996. It tried to secure a bid, but it was unsuccessful. This clearly demonstrates that there was an intention to carry on business in India, which did not fructify. Supreme Court did not agree with the High Court that PF was not carrying on business because it had no subsisting contract with ONGC during the relevant period. Supreme Court also did not agree with the High Court's view that PF did not have a permanent establishment in India and was corresponding with ONGC from its foreign office. And hence it cannot be said that PF is carrying on business in India. So High Court said, no, no, you don't have a permanent establishment. You don't have any office in India. You are only corresponding with ONGC from your foreign office. Since you are not having any office in India, you are not carrying on any business in India. This is the view of High Court, which the Supreme Court is not agreeing. Supreme Court said the view is wholly fallacious and contrary to the very scheme of Act. The Act does not require, Income Tax Act does not require a non-resident company to have a permanent office in India to be chargeable to tax on any income accruing in India. Supreme Court said, after perusing Section 4, Section 5.2, read with Section 911, a non-resident person shall be liable to pay tax on income which is deemed to accrue or arise in India. Income accruing or arising, directly or indirectly, through or any business connection in India, is deemed to accrue or arise in India. This is chargeable to tax as business income. None of these provisions make it mandatory for a non-resident assessee to have a permanent establishment in India to carry on business or have any business connection in India. The issue of permanent establishment is relevant only for the purpose of double tax avoidance agreement. Otherwise, there is no requirement, mandatory requirement that you must have an office in India. Supreme Court said, in an era of globalization, whose lifeblood is transnational trade and commerce, the High Court's view that a non-resident company making business communication with an Indian entity from its foreign office cannot be construed to be carrying on business in India is wholly anachronistic with India's commitment to sustainable development goal relating to ease of doing business across national borders. On the above basis, Supreme Court allowed the appeal of the PF and restored the order of IT-80. We have already seen IT-80 allowed the claim of business expenditure and also the depreciation on furniture, unabsorbed depreciation on furniture and fixtures. Thank you very much. Have a great evening. Bye.